I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are opening the door to compilation 128. And in this particular compilation, we're going to focus on a specific type of case, and those are cases dealing with child support. Today we will be in 3 different judges' courtrooms. Before I give you the rundown on those judges, just know that there will be chapters added for your convenience. And in this particular compilation, there will be some commentary at the end of some of these proceedings. Now, the first judge courtroom that we will be in is that of Judge David Wolf out of the state of Tennessee. Second, we will be in the courtroom of Judge Brock Swartzel out of the state of Michigan. And last but not least, we will be in the courtroom of Judge Claire Jason out of the state of Georgia. As always, it is a pleasure to bring you guys these compilations. And now let's go ahead and jump into 128.
All right, Mr. Butler has filed a motion to alter or amend the judgment in this case. And Mr. Butler, this is your motion, so I'll be glad to hear you.
Yes, sir.
Come to the podium.
Yes, sir. It's hard to remember. I'm currently incarcerated right now, and trying to remember everything since I've had no time to really prepare since this. I've also filed a motion for mistrial, and is that part of this too?
I have a motion to alter or amend, and I then have a.
No, sorry.
So I'm giving you an opportunity to address all of the issues that you have raised in your motion to alter or amend. Do you not have a copy of it?
Not with me, no, sir, because I'm incarcerated right now due to being targeted.
Let me tell you what you said in your motion. Says that you're filing this motion pro se pursuant to rules of civil procedure 59.04 to alter or amend the final judgment in the following basis. You allege the final hearing was held in the matter on July 14th, 2025 and July 15th, 2025. The court's judgment is based on erroneous findings of fact and the fundamental failure of due process, which constitutes a manifest injustice. And do you want to address that issue and what it is that you're saying occurred
Yeah, the illegal ex parte meeting that happened during the trial that happened, and then also I think it was $800 a month I was supposed to pay in child support, and that was based on her income. And I do remember you specifically saying that the child support should not be based on her income due to me. Like I was laid off from my job, and I wasn't looking for a job because I am, and I've never made as much money as she has.
Well, I want to address that second statement you made. Paragraph 3 of your motion states the court engaged in improper ex parte communication. During respondent's cross-examination of the petitioner on July 14, 2025, the presiding judge, the petitioner, and the petitioner's attorney exited the courtroom and held a private meeting in the judge's chambers. The respondent was excluded from this meeting, which violated his fundamental right to due process in the Tennessee Code of Judicial Conduct, Rule 2.9.
Yes, sir, that did happen.
You're alleging that I had a communication with the attorney for the petitioner and the petitioner and about your case?
I'm not exactly sure what happened. I just know that.
Well, you've made an allegation, which I consider to be a very serious allegation.
Sure.
When I'm talking, just wait for me to finish. So I want to know what proof you have that such a meeting took place, because I can tell you it did not. But I want to hear what evidence you have that you would have placed in such a motion.
So the only evidence I have is that when we were here, and I was actually questioning Mrs. Butler, that all of a sudden Miss Margaret got up and then she got up, and I noticed that you three went through that door, and then I was just left standing here. I didn't know what to do, so I went back and I sat where that man in the blue shirt is right there. I went back and sat right there for about 10 minutes. Miss Butler exited that door, and then about 5 minutes after Miss Butler came out, Miss Margaret came out and then you came out. I don't know what you guys said. I just know that.
So
That
you have
happened.
no evidence that any such so-called meeting occurred between me and Miss Brady and the petitioner in this case. You're just assuming that such a meeting occurred because we left the courtroom at the same time. Is that
I
correct?
just don't know what else would have happened. I did file for a mistrial first, and I don't know why that didn't come through. But I do know that I wasn't getting dates while I was filing stuff. So I tried to, did the mistrial first to make things. I don't know if it would make it right better or I'm just trying to do the best I can, Your Honor. I lost my son. I was doing everything right. Like the courts asked me to take a drug test. I passed it. I didn't get my son. I lost my son on false allegations of drug use, and did everything the courts asked me to do. I still didn't get my son back. I lost everything, Your Honor. I lost literally everything, and I've had the Cheatham County Police. They targeted me, and I've got evidence of that. And it's just, I mean, look at me. I mean,
Paragraph 4, you allege that the petitioner provided false testimony under oath regarding allegations of domestic violence, which the court relied upon in its ruling. You vehemently deny the allegation that you jammed your thumbs into the petitioner's eyes or punched her. Basically, you're saying that I relied upon a false testimony, but I heard both sides of that testimony. Well, I heard her testimony, and I think you were pending criminal charges at the time, correct?
yes, sir.
Okay. The paragraph 5, the court's judgment relies on a pattern of false allegations. Prior to the final hearing, the petitioner filed an ex parte motion to suspend your parenting time based on claims of drug use and unsafe home. Those claims were investigated by the Department of Children's Services and were proven false. Furthermore, you passed a court-acknowledged 10-panel hair follicle drug test. Anything you want to add to that? I'm considering your motion, so I'm giving you an opportunity to
Yes, sir.
provide me with any kind of proof regarding your allegations.
There was also there's the allegations that I was homeless, and then they came and inspected my house as well, and did a home visit, and she saw I lived in a beautiful home. I was very stable, and after that, Judge Turnbow, I didn't get to get back in front of him because he went. They go. I guess y'all guys alternate. So I filed another motion, and I was running late to court that day due to my car issue, and I've since filed a motion for that. And but I called as quickly as I could, and the lady said that your case had already been heard, and they're not going to do anything. And I was just devastated. I was just like, because I thought that would be the day I get my son back.
All right. Paragraph 6, the allegation of harassment at the ninja class is further evidence of this pattern. The petitioner obtained an order of protection based on claims of harassment and threats. The incident did not occur. Class was held in a small room filled with numerous parents and children. No independent witnesses came forward to support the petitioner's story because it did not happen. Paragraph 7, the petitioner's attorney made false representations to the court. The respondent inadvertently sent a draft email with no threats to attorney Margaret Brady. Attorney Brady then falsely told individuals in the courtroom that the email contained threats and a deliberate attempt to poison the proceeding. So you had filed a motion making these allegations, and today is your day to show to the court the basis for any of those allegations.
Sure. So for the ninja class, it was worded in such a way that I so happily showed up there, and I feel like the way that things were worded to obtain this no contact order, it was specifically for that and for that only. And just before that incident, or there really was no incident, I was trying to break contact off of Miss Butler because of just how angry she was, and I just wanted to support my son. I've been there since day one supporting my son, And for whatever reason, these people just come out of nowhere and just don't want me in his life. And that's exactly what has happened. And then there was no need for a no contact order. There was no need for that at all. And it was there strategically to violate me 100%. And it was malicious, if you ask me. That's how I feel. I don't have anything with me right now. But and then also my probation was violated at the wrong place at the wrong time, and I'm fighting those charges and more than likely will win. And Miss Brady, before the proceeding of the violation, was telling the courtroom that I have a draft email, and for whatever reason, it was addressed to her, and it was nothing of the sort of threatening. And Miss Brady was talking about it in the courtroom the day before my violation was set to be heard. And my attorney said, "Where's this threatening email?" And I gave it to him. I said, "Here." And there was nothing in there threatening. So for whatever reason, I felt like she was trying to poison the well before it even got started. Because, her sister-in-law does work down there.
All right. Have a seat at the table. Ms. Brady, do you want to respond to the motion to alter or amend the judgment?
We would just say that,
You'll come to the podium so let's pick up.
obviously, we would say there's no ex parte communication with the court. But all the other things that he mentioned in his motion are based on witness testimony, and the court had that opportunity to hear that then and deemed Ms. Butler's version of events to be credible and made a ruling based on that. And we would say that there's no grounds for to alter or amend this judgment put forth by Mr. Butler today, and we'd ask that be dismissed and this be considered a final order.
Number one, the court specifically will address the allegation that the court engaged in an improper ex parte communication. Mr. Butler has affirmed on the record that he has no evidence of such a meeting occurring other than the fact that circumstantially Ms. Butler and her attorney, Ms. Brady, exited the courtroom and that I exited the courtroom at the same time. That alleged meeting did not occur. There was no ex parte communication between me and Ms. Brady and Ms. Butler. And I specifically find that allegation was made without any evidence and nothing more than circumstantial belief by Mr. Butler that somehow something was being done inappropriately. So I find that basis is a false allegation regarding the behavior of this court and that of Mrs. Brady as the attorney for Ms. Butler. In addition to that, all of the other, as Ms. Brady has pointed out, all of the other allegations that he makes are all basically complaints regarding the court's findings at an evidentiary hearing. And the court finds that the testimony that was offered at that hearing was the basis for the court's order that was entered, the final hearing order. And that final hearing order was filed September the 2nd, 2025, which was after his motion to alter or amend. And that hearing order was based upon the facts as were presented in this court at the final hearing, where Mr. Butler was present, given an opportunity to participate, and that as a result of that, no evidence has been brought forward to satisfy the court that there's any basis for an alteration or amendment to the court's prior order. Therefore, his motion to alter or amend the judgment filed August 25th of 2025 is overruled. Then there are some additional motions that have been filed, and I would like to address those motions, and Ms. Brady, unless you need additional time to consider them. He has filed on October the 1st a motion to reconsider and amend the final order as to child support.
Which, not be the top of your list. I filed a motion to dismiss all of the remaining motion and for sanction. And so if we have argument on my motion to dismiss, it might resolve those motions. Might be a way to handle it. We won't be able to see.
We'll consider your motion to dismiss, considering, and consider that before we take up any of these other motions, because if your motion is valid, then it will not be necessary to consider those additional motions.
Your Honor, so the other motions were not, as you know, set on the docket today, but I wanted to bring them all up before the court today so we could just deal with this all together. So as you can see, I filed a motion to dismiss. He has additionally the motion to reconsider and amend as to child support, an emergency motion to reinstate parenting time, and for immediate hearing, a motion for mistrial. There was a motion for personal items that's already been dismissed by Judge Turnbow because for failure to prosecute. So on these remaining motions, Your Honor, I would say that these are going to fall kind of in the same lump as the motion to alter or amend. They're all based upon problems that Mr. Butler has with testimony that the court considered that he had an opportunity to cross-examine and participate in that hearing. And we would ask that all of those be dismissed. And furthermore, Your Honor, we've also asked for sanctions pursuant to Rule 11.02. And specifically, Ms. Butler is asking that she be reimbursed for her attorney's fees to defend this motion today. As we know, there's been a history of harassment and stalking and domestic assault. And now that Mr. Butler is unable to do that out on the street, he's using this court to continue this harassment because he's dissatisfied with the court's ruling. And he has had no basis for these motions. And so we would ask that he be responsible for attorney's fees today. Additionally, though this was very late filed, and I'll acknowledge that, I filed a motion to relocate, and also we're having a problem selling the house. I understand if Mr. Butler doesn't want to deal with that today, he has that right. But you had asked that if we can't get the house sold at list price, that we need to come back and talk to you about that. And they've had one showing the whole time that it's been on the market with no movement. And we're asking that if the court will hear that today, that we be allowed to accept the reasonable recommendation of Amanda Bell, who is the realtor, and just try to get this house sold. But I understand if that needs to be reset.
When you say I had asked you to come back and talk to me, you were talking about having come back to court on that issue.
Yes, Your Honor. So in our final hearing or final decree, you had said if she's not able to sell it at list price, that we needed to get permission from the court to reduce that price so that there was a basis for it. And if you need to hear from Ms. Butler, we can do that to describe
you
that.
just filed it yesterday, so I'm not going to require Mr. Butler to have a hearing on that particular issue because of the fact that he's entitled to 5 days notice prior to that. We can set it later in this month for a hearing, but it would not have to be, it would not be fair to him to have a hearing today with a motion filed yesterday.
I understand.
Mr. Butler, did you raise your hand? Do you have something you wish to say?
Yes, sir. The house is listed way too high. It's listed at like almost
Up to
400,000.
the podium.
She has the house listed way too high. It's at 400,000. It's not worth that much. I understand that the market value has fluctuated these last few years, but it was nowhere close to that. And then also with the motion for emergency custody was because I satisfied everything the court needed me to do. But right now I'm incarcerated right now with no probable cause. So, that's why I can't keep up with everything. And a lot of this is not based on, so I don't know. I've lost everything. I lost my son. I've lost literally everything for nothing. And they just want to take more and more and more and more. I can't even afford a lawyer, but I got to pay for her lawyer fee. And then they got the house marked up way too high. And then, Your Honor, I just really hope you'll take into consideration that, you know, a lot of this was done, and I have been targeted by the Cheatham County Sheriff's Office. They violated my probation the first time based on words, and then I've got proof of it. I've got proof of it, and a lot of it came from her. And I just really hope you'll take that into consideration, Your Honor. I mean, I've been a good parent. I'm a supportive parent. I've worked our entire marriage. I've worked until I lost my job. And then on top of that, I didn't just sit there. I went out and I made money. It wasn't, you know, a bum. I did what I could for my son. I went from being that dad every day with my son to nothing. And they just took everything out of my life. I'm in jail right now for nothing because they targeted me because she could win 100%.
All right. You have also, and Ms. Brady, I'm going to go ahead and consider these other motions on the record because it's my understanding he's filed an appeal. Is that correct? He's filed a notice of appeal to the Court of Civil Appeals, and therefore I think that all of these motions need to be addressed that he has raised regarding the final hearing. So the next motion that I'm going to take up is an emergency motion to reinstate parenting time for immediate hearing. Mr. Butler, you have filed a motion to reinstate your parenting time.
Yes, sir. I did. That was before I was on private property, and the Cheatham County Sheriff's Office came up and arrested me for being on private property, and now I'm here. And so if I were to win this, I guess I couldn't get it anyway because I'm incarcerated. But so I don't know if maybe when I get out, if you were to give it to me. But Miss Butler's whole goal was to move back to East Tennessee, where she was from. That's why this, you know, the no contact order for no reason came into play. And that's why a lot of this is like the whole targeting thing is like so aggressive, is so that way she can move back to East Tennessee. 5 hours away. I mean, no, not that I'm a bad dad, not that, you know, I'm out partying, I'm out doing drugs, nothing. It's just bullshit. And they've got me hemmed up. I mean, it's hard when you're a small guy. You got no lawyer. I did have a lawyer. She withdrew from my case because of Margaret Brady. I've got her on tape saying that. She doesn't want to go against Margaret Brady. She's took all my money, so I had no money left, so I had to defend myself, and I still lost fucking everything. I mean, I've lost everything, Your Honor. I'm sorry. I'm not. It's just. I mean, I'm a good dad that's fighting to be with his son, and I just keep getting shot in the foot. It's pretty bad. It's pretty bad.
Right. Your motion to reinstate parenting time for immediate hearing is going to be denied simply because of the fact that you're incarcerated. I'm not going to reinstate parenting time because you are incarcerated, but the final order in this case provided that upon your release from jail that you would have the right to exercise supervised visitation every other Saturday and Sunday from 9 a.m. to 5 p.m. each day with no overnights. That would be supervised by a third party agreed upon by the parties. That you would be permitted to petition the court for review of your parenting time after your criminal charges were resolved without the necessity of showing a material change of circumstances. I don't know how it could be any more fair with you in the situation that you're in. All of your argument has to do with how unfair you think it is that you're incarcerated. That's not an issue before this court. The fact of the matter is you are incarcerated.
You're right.
And because of that fact, you're not going to have visitation with your minor child or children until you are resolved of that. And this final order that I put down provides a method by which you can have visitation, and you can even have it reviewed after all your criminal matters are resolved to try to reinstate some sort of a normal visitation. So your motion to reinstate and your visitation immediately is denied based upon the fact that there is provision in the order for that to take place. The next motion that you have is a motion for a mistrial, and I will just simply, I don't even need to hear any argument. Your motion for a mistrial is based upon paragraph 1, ex parte communication, July 14th, 2025, during the final hearing of this matter, the presiding judge, Judge Wolf, plaintiff Aaron Butler and plaintiff's counsel Margaret Brady left the courtroom together and entered into the judge's chambers for approximately 20 minutes. Defendant Robert Butler was not invited nor informed of the content of the discussions and was not given an opportunity to respond. The ex parte communication deprived the defendant of due process. I've already addressed that issue with you. You have affirmed on the record that you have no evidence of any such meeting occurring, that it was all circumstantial because I left through this door to my right, they left through the door to my left, and as a result, during a recess of this court, that you assumed that there was some sort of ex parte communication. I affirm on the record that no such communication took place and no such meeting took place, and that allegation was based upon a false statement by you. Therefore, your motion for a mistrial is denied. All of the rest of this, of your motion for a mistrial, which is not appropriate after the final, you don't file a mistrial motion after the case is concluded. And for that reason, in addition to the fact that I've considered all of the other bases, and there is no basis for a mistrial to be granted after the entry of the final order in this case. The last motion is a motion to reconsider and amend the final order as to child support. And at that point in time, I found that the mother's income was set at $6,000 a month in the final hearing, that your income was imputed even though you were in jail pursuant to the rules of the child support guidelines, simply because of the fact that if you were unemployed, it was due to your own fault. As a result of that, you could have the imputed income that the child support guidelines provide. I applied that to the calculation of child support, and therefore you're not entitled to an amendment as to the calculation of child support. That concludes all of the motions that are set, other than the motion to relocate, which was filed yesterday. I will not consider that until he's been given appropriate notice, an opportunity, and that would be later in the month that we have a chancery day we can set it.
Your Honor, I know that we're not taking up the motion for reducing the price of the home either, but since Mr. Butler seems to be on the same page as that, you think that we could consider that, and we can get that house sold and they can get some funds?
If he's willing to do it, we can. I mean, if he's willing to waive the 5 days notice and have it heard, yes. Mr. Butler, the rules of civil procedure provide that you're entitled to 5 days notice prior to the hearing on a motion that's been filed. They filed their motion to reduce the value of the property and to accept an offer less than the listing price yesterday. So therefore, you have a right to object to that, and I'll have it set later in the month, or you can agree to hear it today, and then we'll put on the proof, let them put on the proof about why they need to accept this offer. Do you understand all that?
I understand it all. I guess it just depends on how much they want to reduce the price. If she wants to work out a deal or something, I might be willing to talk about it for a minute.
Go ahead and have a seat over here, Mr. Butler, and I'm going to let Miss Brady talk with you, and we'll come back to you.
I think that we probably should just reset both of those motions so we can get a clean order from the court, because I'm not sure the agreement that we might be able to reach is going to be workable.
Right. What day in the 24th of November?
All right. Thank you, Your Honor.
Butler, those remaining motions will be heard by this court on November 24th. Thank you.
I believe you're entitled to 10 minutes of oral argument. If you wouldn't mind putting your name on the record, please.
I'm the executor and sole beneficiary of the trust and estate of Mr. Kevin Dwayne Craft, the legal persona. I am not here making a general appearance. I'm here by special divine appearance, judge, to settle a matter, to call for a constitutional court of record to ask for a summary judgment upon the truth and facts that I placed upon the record with my documents. I stand firmly on my rights, and I'm here to ask for the summary judgment, please.
You've asked for.
I do also have a few questions.
The I understand your pro se, and then therefore you get a little bit of leeway, but typically the judges don't answer questions. We're the ones who ask questions. This isn't like a trial court where it's a very kind of back and forth, back and forth, back and forth. The Court of Appeals is more structured in terms of the lawyers or parties come up, they make their arguments. The judges may or may not have questions for the person, and then it's submitted, and then we go back and discuss the matter. And then at some point in the future, we come out with an opinion. So it is different in that respect than trial court.
Understood. But I am wondering if this is a court of constitution, and would the Constitution be applied in these proceedings?
The Court of Appeals, the Michigan Court of Appeals, is provided for under the state Constitution of 1963.
Is that a yes?
That's the answer I'm giving you.
Okay. I'm asking to verify to make sure these proceedings are legitimate. The Constitution has two jurisdictions: common law, admiralty law, or maritime tribunal. And I'm asking in which context would this court try to enforce jurisdiction on me?
We're acting under the state Constitution of Michigan of 1963.
Moving forward, I'm here to pretty much address the court's error for ignoring my motions. Notice of dismissal, default judgment under Federal Rule 55 was filed December 12, 2022. Under Federal Rule 55, if a party fails to respond to the defendants themselves, and this is confirmed by my affidavits and other means, the clerk must officially record a default judgment of that party. I filed several motions and they were ignored. That's why I'm here. In Haynes versus Kennar, 404 U.S. 519, 1972, courts must be understanding and not easily reject motions from people just representing themselves. And that's what took place in this matter. In Article 1, Section 17 of the Michigan Constitution prevents courts from ignoring motions and guarantees that people have a fair chance to represent themselves in any argument and evidence. That did not happen. That's why we're here. The state ordered me to take a paternity test. And Monell versus Department of Social Services, which is a New York State case. The Supreme Court case established that municipalities' liability under the Section 1983 for constitutional violations in the context of child support cases, where the appellant argues that a warrant should be required for me obtaining genetic and biological material. I think it's very sensitive when a state injects an order asking me to give genetic and biological material without a warrant. That's really sensitive material. It's not like a document or anything. That's personal biological material. That's why those specimens were not granted. That's why I deny any consent or any contract with the state or Title 4D agency to give away my biological and genetic material. That the case Monell is relevant because it underscores the importance to ensure that government agencies like the friend of the court on this context. These are for-profit agencies disguised as government agencies like the friend of the court, adhere to constitutional standards where collecting evidence potentially implying the need of procedure safeguards to protect individuals' Fourth Amendment. That's why I asked, was this a constitutional court? The asking for genetic material is protected by my Fourth Amendment right. The Fourth Amendment protects individuals from unreasonable searches and seizures and safeguards one's privacy and assurance that any such search is conducted within the boundaries of legal requirements. I see that they're not here today, and that's some questions that are raised, and those were my concerns. On August 11, 2022, the Kent County ordered an appointment for me for genetic and biological testing. In a testing laboratory, DNA Diagnostic Center is a business, and I can prove it's a business because I have their Dun and Bradstreet numbers. 877-184226 for the record. They also said, when I thought this was funny, the state of Michigan stated that it would pay the cost of the genetic test. And if I wasn't excluded, that I would be responsible for that cost. And with that being said, that set alarms. The state of Michigan is also a business. And with them fronting the cost for me, that presented an alarm for me because I don't choose the contract with the state of Michigan. I don't choose to do business with them in this regard with another business. It seems like a coercion of some sort for them to upfront the cost if I was going to be responsible. I do not consent to that business arrangement. The state, they failed to show a promissory note of a contract of any sort. I submitted documents, notice to the court to demand dismissal for lack of jurisdiction, demanded to see an open court evidence of personal and subject matter jurisdiction, and notice of court to refusing to appear voluntary. And I do not accept the offer to contract, and I do not consent to these proceedings. That affidavit or notice to motion was submitted on November 28th, 2022. So again, I'm just bringing up the point that I submitted numerous of documents asking for clear evidence or asking for due process, also asking for just quite frankly, to be transparent with what's happening. And I believe I deserve the right to see in writing what gives them the authority and what contract am I entering. I want full disclosure. In Burns 322 BR 719, a creditor must provide proper documentation such as a promissory note contract to substantiate a debt or court claim. They did not. More documents I found. Affidavit inserting corporate nature of government entities. I submitted that document because I'm concerned that these are for-profit businesses disguised as government agencies. You know, I have proof. Kent County Court, Dun and Bradstreet number for the record, 152906082. Kent County Friend of the Court, Dun and Bradstreet number, 6088333133. State of Michigan, Dun and Bradstreet number, 504698428. These are businesses. I would like to state for the record that I am not a corporation. I'm a living, breathing person, human being. With these being businesses, they have to abide by the same rules as other businesses. And may I give an example? For example, McDonald's. McDonald's can't force me to eat their Big Macs. They need my consent. None of these businesses that I've mentioned have my consent to do business with them. Section 458 of the Social Security Act, incentive payments to state. It's a conflict of interest. And it's my argument right here, right now, that the state incentivizes them it incentivizes them to collect more child support. The main argument I have here and for you guys is full disclosure. You know, it seems like they enter me in a contract without my consent, without full disclosure, and that's the problem here. You know, I'm here to argue subject matter and lack of jurisdiction. No evidence was established in my involvement of a common law crime or damages, and I did not commit any common law crime. Notice of court to refusing to appear voluntary, and I do not accept these contracts, and I do not consent to these proceedings was another motion or notice to motion that I submitted 11/28/22, and it's basically it's evidence. They didn't provide any evidence of an injury or injured party. And
Mr. Kraft, you're out of time. We understand that you raise issues of disclosure,
yes,
jurisdiction, remedy, and as I indicated, your brief, as with all the appellants and appellees we have here today, the briefs that you submit are kind of the key issue or the key tool that we use to resolve cases. And so I just want you to know, we have your brief. We're going to go back. We've had research attorneys look at it. We're going to look at it again. We're going to discuss your case. And then you'll get an opinion from us sometime within the next few weeks.
If I may, one last thing.
You've got, if you can do it in 20 seconds.
I can. The government must prove charges beyond a reasonable doubt with clear evidence, especially when making the claims against someone. And I'm asking you guys right here, right now, they did not provide any evidence against me. And I would ask you to dismiss this without prejudice.
Well, guys, we've come to the end of another very interesting proceeding. And the reason why I say that is because I've never seen anybody use the sovereign citizen script in this manner, in a way where, you know, they're trying to use it to avoid taking a paternity test to possibly have to pay child support if that child is his. I've never seen that before, but we see the first thing he does is, he says he wants to check and see if this court is legitimate. But once again, something that we see sovereign citizens do that doesn't make sense is he challenged jurisdiction, but he was the one that put in to the court of appeals. So that just didn't really make sense. If you're challenging the jurisdiction of the court, or you don't believe the court has jurisdiction over you, then why would you try to turn to the court, for help in this matter, right? It just doesn't really make sense. And we hear him keep saying, I choose not to contract with these companies, they're corporations. He kept sharing the Dun and Bradstreet numbers. But it sounds like to me, I don't want to assume that he doesn't want to pay child support. I mean, I don't know what his relationship with the young lady is, but obviously he's using this sovereign citizen script to try to get out of taking this paternity test. It could be a number of reasons. It could be because he doesn't want to be with the girl, doesn't want the child, doesn't want to pay child support, doesn't believe the child is his. It could be a number of reasons. I'm not here to assume, but it definitely was very interesting to watch and see. If I get any updates on this case or what ended up happening, if they made him take the test or not, I'll let you guys know. But with that being said, guys, that's it from me. This is Sovereign Citizens Hall of Fame. And for now, guys, Sovereign Citizens Court is adjourned. See you guys in the next proceeding. God bless.
Good morning to both of you. This case has been going on since May of last year. In this case, Ms. Simmons has an order for $437 a month as the primary payment for child support, and she has a payment of $87 a month as a repay. For my mind is not that efficient to figure out the amount, so let me just put what he's supposed to be paying. 437 plus 87, I think is what I said. All right, the child support payment is supposed to be $524 a month. Looking at my notes over time, both parties were present in June of last year, and then in August of last year. I've given multiple resets, and then he was here October, and then I dismissed the case because you were consistent in October of 2023. Then in August of 2024, she refiled because you stopped making payments. And then I set a Zoom date. I actually issued a warrant for your arrest. But we reset the case because you came in person and indicated that you did not get the hearing notice. I don't usually give second opportunities when I've worked with you for a whole year to get you back on track, and then you just fall off. Generally, that's a problem because you're under an order to pay child support, and I've already given you the opportunity of what I call redeeming yourself. Looking at the order, Mom has custody of Abraham, Asher, and Naomi, 3 children. That's not a lot of child support for 3 children anyway, but all right. And so looking at your child support order, it looks like Mom was receiving unemployment payments for April. And then when we came to court last month, DCSS said that they saw that you may have had a job and they were trying to see if they could get the child support taken directly out of your paycheck. I reset the case to give you a chance that if there's an income deduction order, I would recall the warrant and let the income deduction order continue to proceed, but there's nothing to date. So last payment mom received was April, I believe. And so that's May, June, July, August, September, October, November, 7 months, 3 kids, no support at all. Is what I'm showing. Okay, yes, you can raise your hand. Yes, Ms. Simmons.
I submitted evidence as well. It was something that Mr. Simmons had filed with Superior Court, I believe. So I think they may have it. They said they were going to upload it for you to be able to see it.
Okay, give me one moment. Mr. Keys, Joshua, do you see anything from her that you could forward to me?
Yeah, let me give me 1 second. Hold on. I'll look.
Okay, give me one moment, please. And you sent it to the magistrate court clerks, Ms. Simmons? Okay, give me
Yeah,
one moment.
they made a copy of it. Yeah, I took it into the office.
Okay. All right, well, I'm waiting on the information from Ms. Simmons. Ms. Serena Camarillo, is there any update on the information that was sent in on the ID?
Yeah, I'm not sure when the last meeting with the court was. What I can say is that on August 22nd, we received a response from an employer via fax stating that he was no longer employed at the location where we had sent the income withholding order to. They said he was no longer employed there as of August 22nd, 2024.
All right, Mr. Simmons, while I'm waiting for Ms. Simmons' information to be sent, mind you, I've already issued the warrant for your arrest, but you can go ahead and explain to me why you haven't paid any child support in the past 7 months. You have to unmute yourself, sir.
Yes, Your Honor. I'm appearing under special appearance exclusively to address the challenge to jurisdiction. I request that no substantial matters proceed until jurisdiction clarification is fully resolved over my personal property. For the record, I request that all responses to the questions in my demand for clarification on jurisdiction be fully documented in court record. So a clarification of demand that was sent, that should be filed. That's what you're referring to. Demand for clarification of jurisdiction.
Okay. You have a child support order. Ms. Simmons has a child support order in DeKalb County. You are under an order to pay child support. In the state of Georgia, it is a crime to not support your children for 30 days. The law states that the case should be filed where the mother resides with the children. Ms. Simmons, I'm just going to unmute you. Ms. Simmons, where do you reside at this time?
DeKalb County.
DeKalb County, and where do the children reside?
Yeah, also DeKalb County and Stone Mountain.
And where are they attending school? In what jurisdiction?
DeKalb County, Stone Mountain, DeKalb County.
Okay, thank you. For criminal purposes, I do find I have jurisdiction over you, Mr. Simmons. You are the father of these 3 children. There's an existing child support order for you to pay child support. You're failing to pay the child support. You have not paid child support in 7 months. I'm still waiting, so give me one moment before I proceed. You don't want to explain to me why you're not working, what you're doing. You have 3 children with Ms. Simmons, and you're not making any effort to comply with my order. The jurisdiction is determined that I absolutely have jurisdiction over you because your children are not being provided for by you. The last time we received was some unemployment in April and nothing since then. So there's jurisdiction over you. What else do you want to address, Mr. Simmons?
Your Honor, my demand includes several fundamental questions regarding the nature of the court's authority. I respectfully request the court provide clear answers to these questions before asserting jurisdiction over my personal property. Specifically, is the state of Georgia operating as a corporation or as
Sir, I'm not entertaining those questions.
Yes.
Those are sovereign citizens questions, and I'm not answering those questions. So I'm going to mute you for right now. I have jurisdiction over you. I have jurisdiction over your children. This is an appropriate proceeding. This is a government entity, and I have jurisdiction over our court in DeKalb County have jurisdictions over you. So this is the sovereign citizen kind of thing where people act like they're not, or they present that they're not members of the United States. And yeah, no, sorry, sir. You can present whatever you want in writing, but I've already determined I have jurisdiction. You've appeared in court before. You've never made an issue, so I'm not going to let you try to say we don't have jurisdiction over you. You've appeared multiple times before. All right, so give me one moment.
We looked in the inbox as well as look on the file. We do not see anything on file as far as from Ms. Simmons. Not saying she didn't, but we don't see anything in the actual inbox or attached to her file.
Do you have it already scanned, Ms. Simmons?
Myself, no. They did also stamp it to say that it was received by magistrate court as well. So,
Okay, well, you can just tell me what it was. What was it?
yeah, Mr. Simmons, he submitted something apparently to Superior Court. I received a certified copy of a letter in the mail, stating basically that he believed that he should not be liable to pay child support because he did not agree to pay child support. Essentially, he said that he was under duress in having to pay child support. That was
Okay.
the basis of his.
All right. So there are a number of like entities out that go and challenge jurisdiction and, you know, the things that he's trying to do, reading some script of narrative that the judge doesn't have jurisdiction. And sometimes they say they're not a legal person. And yeah, I'm finding that you are a legal person. You've already appeared before the court, so you can't bring any new argument before the court. I do find that you're intentionally abandoning your 3 minor children. So I am issuing the warrant for your arrest, sir. You can turn yourself into DeKalb County Jail. Ms. Simmons, unfortunately, this doesn't expedite. It's just going to go to court. They will arrest him when it's time. They'll take him into custody, and then your case is going to be transferred to state court. So once your case is transferred to state court, Mr. Simmons, if you are recording this proceeding, I am going to hold you in contempt and I can issue another warrant for your arrest. You are not to record this proceeding.
I'm not actually recording. My advice is to make sure that this is being represented accurately.
Are you recording this proceeding, Mr. Simmons?
No, I'm not recording this proceeding at all.
All right, thank you. Well, I was trying to give you an opportunity to explain why you haven't paid child support. You're determined, you tried to address jurisdiction. I find there's jurisdiction over you, your children. So with that being said, sir, a warrant's been issued for your arrest. You're not providing support since April. And you did good. You got off the case and then you decided to go this route. That's on you. So $2,000 regular bond. Usually I give unsecured judicial releases, but I'm not because it's your second time before court. You can turn yourself in if you choose. If not, then there'll be a warrant outstanding for your arrest. And when they pick you up,
okay. I'm making special appearance to actually address the jurisdiction. And so what I'm trying to do is clarify that first. I know you mentioned about jurisdiction, but I'm trying to answer the questions that are in the demand for clarification for jurisdiction. So those questions that was actually submitted, and I'm waiting for you to open.
Oh, that's not me. That's Superior Court. I'm not.
No. I walked it in personally to the magistrate court. I put it in there. The same document she's talking about. I put that.
Okay, sir. You can ask me the questions about jurisdiction. I've already told you I have jurisdiction because your wife and your ex-wife and your 3 children live in DeKalb County under Georgia law. I have jurisdiction over the case. What other question do you have? And because you're the father that birthed those 3 children, you're the one that I find is committing a criminal offense. So a warrant's been issued for your arrest. What question do you have about jurisdiction?
Is this jurisdiction being fully documented in a court of record?
Yes, it is.
Okay. And apart from that, when I mentioned about the request for the court to provide clear answers to the questions before a certain jurisdiction of my personal property, they're written in the clarification for demand that was filed.
I'm not taking any jurisdiction over your personal property, sir. I'm taking jurisdiction over you. And a state court will decide whether or not you're going to go before a judge or jury. So that concludes our hearing, sir. Ms. Simmons, you'll just go to the DeKalb County court and they will DeKalb County State Court, your case has been transferred. Mr. Simmons has not paid support. Seems like he's not going to pay support. So I would also recommend through child support that you file a motion for contempt because I'm sure he has the ability to take care of himself. And he sounds to me like he's challenging whether or not these children should be supported by him. So, sir, you could take that up in Superior Court, but for criminal purposes, I've already determined that we have jurisdiction. Okay, that concludes our hearing. Ms. Simmons, if you go to Odyssey, DeKalb County Odyssey, do not unmute yourself without my permission, sir. In Odyssey, you have to track your case. Okay, give it about probably beginning of the year. Go into DeKalb County Odyssey, keep putting his name in until you finally see something come up. And once it comes up, try to go to court if you can to advocate for the child support, because sometimes if mom isn't there, it just makes a difference when moms are active with the court and making sure that the support is provided. And I thought, if I don't know, did you have a special needs child one?
Yes,
Yeah.
that's right. Naomi has special needs. Yeah.
Yeah.
She's
Good.
gone
Okay.
through.
Okay.
Chromosomal
All right.
disorder. Yeah.
Okay, I'm so sorry you're going through this, but hopefully you will be able to continue to do the best that you can do with it. All right, that concludes our hearing. All right, Mr. Simmons, you could turn yourself into DeKalb County Jail. If not, there's a warrant outstanding, and when they do a sweep through any different counties, then you'll be arrested and taken into custody. You have a bond of $2,000, and that concludes our hearing. I'll give you one final word if you have a question, Mr. Simmons, but I'm not dealing with jurisdiction questions because I've already determined I have jurisdiction over you. Do you have anything else that you need to say before I conclude the hearing? You can
Yes,
unmute.
I'm here on special appearance.
Okay, thank you. We appreciate your special appearance. You're excused from court. We can go ahead and excuse Mr. Simmons and Ms. Simmons from court, and that concludes our hearing on that case.
Well, guys, we've come to the end of this sad and unfortunate proceeding. I must say that Judge Claire Jason definitely handled her business. She wasn't trying to hear it, wasn't trying to have it. Whatever he tried to throw at her, say, do, she's not with the sovereign citizen nonsense. It's unfortunate to see that he was using the sovereign citizen script, or trying to use the sovereign citizen script, to get out of his responsibilities to take care of his own children, and then to have a special needs child on top of that and be doing this in the courtroom, in spite of what may have happened between him and his ex-wife. Who knows? It's just sad and unfortunate to see, but we see that he has been, a warrant has been issued for his arrest, and it's going to be a $2,000 bond. I'm not sure how this works, but I was just wondering, and maybe you guys know, if he does get caught or turn himself in and post that $2,000 bond, would that go to his wife, his ex-wife, and children? I'm not sure how that works, but nonetheless, if there's any updates on this case, I will definitely inform you guys on that. Thank you as always for joining me. Don't forget to subscribe if you haven't. Like the video, share the video. It helps us with the YouTube algorithm. And with that being said, guys, this is Sovereign Citizens Hall of Fame. And for now, guys, Sovereign Citizens Court is adjourned. I'll talk to you guys soon. God bless.
I'm not threatening you. Say one more word and that's contempt. 30 days. 30 days.